Namaskaram. Important issue related to polity. Okay, polity, constitution, governance. So these issues are very important because these issues are varying from different dimension of the polity, and it is very important for our understanding about the political system in our country as well as in the whole world. So in this video, these topics are generally related to political system of India. So the first topic of today's discussion is Preamble of Indian Constitution. What is the Preamble of Indian Constitution and what is written in this? Second one is Prerogative Writs. We are going to talk about different types of writs, basically 5 writs of the Indian Constitution, and who issue it and what are the purpose of issuing it. Either governor, president, or other private entity have part in it or not, or what is the role of state government, private party, and other constitutional post when Supreme Court or High Court issue a writ regarding their working. Okay. Next one is qualification for a person to be chosen as a member of the Legislative Assembly. Okay, so what are the qualifications a person possesses if he or she want to elected in the Legislative Assembly or Legislative Council? Fourth one is objective behind secular nature of the Indian state. We know that different type of religious community are living in our country. So what are the objective behind the secular nature of Indian state? And the last one is uniform civil code. Okay. In Article 44, we know that in the DPSP Directive Principle of State Policy, mention of Uniform Civil Code or UCC is there. So we have to talk about very briefly about it. And in the last, we are going to solve 5 questions on these topics. Okay. So the first one is Preamble of the Indian Constitution. Just a minute, I think there is some problem. Yeah. So first one is Preamble of the Indian Constitution. We know that in our Indian Constitution, a preamble is there in which different important words are situated there. And after amendment, we also introduce other keywords for the betterment of understanding the Constitution, understanding the preamble, as well as improving the life of human being as well as political system in our country. Okay. So first one is Preamble of the Indian Constitution. Let's talk about it. Preamble of the Indian Constitution. These are the opening words of the Preamble of the Indian Constitution. Okay. So here in below, we write some opening words of the Preamble of the Indian Constitution. Okay. So we talk about we, the people of India. Okay. We, the people of India, having solemnly resolved to constitute India into a sovereign, remember, socialist, secular, democratic, and republic. 5 keywords. First one is we, the people of India. Here it is not about we, the people of, you can say, people of this state or that region. No, we, the people of India. That means people is the full authority of it. Have solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. These are keywords of the political system, and to secure to all its citizens justice of social, economic, and political, liberty of thought, belief, faith, worship, and expression, equality of status and opportunity, and promote among them all, and to promote all this quality among other people. So remember, we, the people of India, solemnly resolve to constitute India into a sovereign, socialist, secular, democratic, and republic, and to secure to all its citizens justice of 3 kinds: social, economic, political, liberty of 5 kinds: thought, expression, belief, faith, and worship, and equality of 2 kinds: status and of opportunity. Here we talk about fraternity. Next one is fraternity. Fraternity is assuring the dignity of the individual and unity and integrity of the nation. Okay, so fraternity is a keyword. Justice is a keyword. Liberty is a keyword. Equality is a keyword. Okay, so justice, equality, fraternity. Justice, liberty, equality, fraternity, as well as sovereign, socialist, secular, democratic, and republic. So these are the keywords. And the last one is in our Constituent Assembly. In our Constituent Assembly, this 26th day of November 1949, it is written in our preamble. Okay, so on the 26th of November 1949, do hereby adopt, enact, and give to ourselves this constitution. So this constitution is adopted and enacted on 26th of November 1949 and given to the people of India. So remember important keywords: justice, liberty, equality, fraternity. we the people of India, as well as sovereign, socialist, secular, democratic republic, injustice, three kinds of justice: social, economic, and political; liberty of 5 point thought expression, belief, faith, and worship; and equality of 2 kind states and of opportunity. Okay, so I hope you understand the whole concept, whole idea of a preamble of the constitution, and it is very important because in this constitution, the word is we the people of India. That means people are the supreme authority in democratic or in our country, in India. So this is our preamble, and it is written here. You can clearly see this is our preamble, and what I talk about clearly written here in the form of keywords also. We the people of India, sovereign, socialist, secular, democratic republic, justice of this, liberty of this, equality of this, fraternity of this. And in our constitution, on the 26th of November 1949, we adopt, enact, and give ourselves the constitution. So very, very important. You have to just, like a song, you have to remember each and every keyword of the preamble. It is very, very important. Okay. Now let's move on to the next topic called prerogative writs. What prerogative writs are? Mandamus is among the prerogative writs. Mandamus is a part of the prerogative writs. An English common law meaning extraordinary writs or order granted by a sovereign. So what is the meaning of prerogative writ? Prerogative writs means extraordinary writs or order. Extraordinary writs or order granted by the sovereign when ordinary legal remedies are inadequate. When ordinary legal remedies are inadequate, then sovereign authority of any country issue a ordinary writ or order. And this is also called prerogative writs. And mandamus is a part of prerogative writs. These prerogative writs are habeas corpus, mandamus, prohibition, certiorari, as quo warranto. So these are 5 important prerogative writs in the Indian Constitution, in the Indian political system. In India, the Supreme Court can issue prerogative writs under Article 32. So under Article 32, Supreme Court issue writs, and under Article 226, High Court issue writs. Here in this discussion, we are focusing on mandamus writ. Okay, so mandamus literally means we command. We command. Meaning of mandamus is we command. That means authority command to the private entity or other you can say organization to do their work if they are not doing legal work in their authority. Okay, so when this mandamus when issued to a person or a body, the writ of mandamus demands some activity on their part. Okay, so when mandamus is issued to a person or a body, that writ demands some activity on their part. That means if they are not fulfilling their duty, then mandamus writ is issued by the Supreme Court and High Court. It ordered the person or body to perform a public or quasi-judicial duty. What is the purpose of mandamus? Mandamus ordered the person or the body to perform public or quasi-judicial duty which they have refused to perform. Okay, so through mandamus, they try to enforce their legal duty. So it orders person or a body to perform public or quasi-judicial duty which they have refused to perform. Remember, not you can say in any pressure or any other work, they are refused to perform, and where no other adequate legal remedy exists to enforce the performance of that duty. If there is no other if there is no other adequate legal remedy is present, then court issue order or you can say writs to perform their duty, and as well as also if that person or body is refused to perform their work. Okay, because this is the purpose of mandamus. No, you can say prerogative writ. It talk about granted by the sovereign when ordinary legal remedy is not adequate. Okay, so here it talk about the same thing. When a person refuses to perform and no other adequate legal remedy is present, then court issue writs. The writ cannot be issued unless the legal duty of a public nature and to whose performance the applicant of the writ has a legal right. Okay, so we cannot issue writ unless the legal duty of the public nature. If the duty is not of a public nature, then we can't issue a writ. If that issue is of a public nature, then we issue a writ, and to whose performance the applicant of a writ has a legal right. Okay, and to performing the duty, that applicant have a legal right. So if these two conditions met, then only these two conditions met, then we are not issuing writ. If this is not met, then we issue a writ. That means if that issue is of a legal duty of a public nature and applicant of a writ has a legal right to perform that duty. Only that we have issue a writ, otherwise not. Okay. Unless the legal duty of public nature or applicant have the right of the legal right or applicant has a writ, applicant of the writ have a legal right. If these two conditions are satisfied, then only we issue a writ, otherwise not. Next one is the remedy is of a discretionary nature. The remedy, or you can say remedy, we can say mandamus writ is of a discretionary nature. A court can refuse to grant it when an alternative remedy exists. If an alternative remedy exists to perform that duty, then court can refuse to grant it. So it is basically depend on the discretionary nature of the judges or courts. However, enforcing fundamental right, we know that enforcing fundamental right is a duty of Supreme Court or High Court. So for enforcing fundamental right, the alternative remedy argument does not hold as much weight. Okay. So we talked about earlier that if alternative remedy argument is present, then court not issuing writ. But in case of fundamental right, this argument not hold a much weight, because it is the duty of the Supreme Court and the High Court to enforce fundamental right. To enforce a fundamental right, it is the duty of Supreme Court and High Court. So the alternative remedy argument is not hold as much weight in this case. In case of fundamental right, that alternative argument is not hold a weight. But in other cases, that hold a strong weight. When a public officer or government does not act, remember, when a public officer and government does not act, that violates the fundamental right. If any public officer, IS, IFPS, or any other government officer, and the government does not act, if they are not doing any activity that affect the fundamental right of a person, and the court would issue a writ of mandamus, remember, because they are not performing their duty, then that's why courts would issue a writ of mandamus against such authority so that the person right are not infringed. If the public officer or government not performing their duty, that means they are escaping from their duty. So court issue mandamus because this violate the fundamental right of the duty. And so it is the duty of the Supreme Court and High Court to enforce these duties because it infringes the fundamental right of the other people. It is the responsibility of Supreme Court and High Court to protect the fundamental right of the person. So if any public officer or government not performing their duty, then court issue mandamus for protection of fundamental right of the person. The writ can also be issued against inferior court or other judicial body. Remember, writ can also be issued against inferior courts and other judicial bodies like session court and other judicial body when they have refused to exercise their jurisdiction and perform their duty. Okay, it is not only issued for public or and other body, it is also issued for other inferior courts and other judicial body. So court issue mandamus to inferior court and other judicial body when they are not performing their duty which are come in their jurisdiction. Okay. Under Article 361, remember this article is very, very important. Under Article 361, mandamus cannot be granted against the president or a governor of a state. If president and governor of a state not performing their duty, so under Article 361, court not issue mandamus to this authority for the exercise and performance of the power and duties of his office, for the exercise and performance of the power and duties of his office, or for any done or purporting to be done by him in the exercise and performance of those power and duties. So basically talk about the president and governor are not performing in their duty. So court have no authority to issue mandamus in their case. Okay, next one is the writ also cannot be issued against a private individual or a body. It also cannot issue against a private individual or body except where the state is in a collusion with the private party. If state is in a collusion with the private party, then court authority issue a writ. But if it is not, then court have no authority to issue writ to private individual or body also, or contravening a provision of the constitution or a statute. Okay, if a state is in a collusion with the private party for contravening a provision of the constitution and statute, then only Supreme Court or High Court or other court issue writ to them, otherwise not. Okay, so it not issue writ to president, governor as well as private individual and a body, except where the state is in a collusion with the private party for contravening a provision of the constitution or a statute. Okay. So in this picture, you can clearly see a writ issued by the court of mandamus centuriori quo warranto, habeas corpus, and prohibition. Okay. And in the above, yeah, here I talk about it. So yeah, now let's go to another topic called qualification for a person to be chosen as a member of a state legislature. Qualification for a, what is the qualification of person to be chosen as a member of a state legislature? That means MLA or MLC. What are the qualifications of any person? So the Constitution lays down the following qualification for a person to be chosen as a member of the state legislature. So for a person to be chosen as a member of a state legislature, Constitution lays down various provisions, various qualifications. First one is he must be a citizen of India. Second, he must make and subscribe to an oath or affirmation before a person authorized by the Election Commission for this purpose. Election Commission authorized a purpose. So before you can say before that person, that guy who is want to become an MLA or MLC must make and subscribe an oath and affirmation. Okay, so MLA and MLC must subscribe an oath and affirmation before a person authorized by the Election Commission for this purpose. And in this oath or affirmation, he swears that MLA MLC swore to bear true faith and allegiance to the Constitution of India. True faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India. So very, very important. Uphold the sovereignty and integrity of India, and to bear true faith and allegiance to the Constitution of India. Okay. Next one is he must not be less than 30 years of age in case of legislative council. If you want to conduct, if you want to elected in the legislative council, so you must, he or she must not have a less than 30 years of age. And for legislative assembly, the age is 25 years. Okay, so if you are above the 25 years, you are eligible for contesting an election of MLA. But if you are below the 30 years of age, you are not eligible of conducting an election for MLC. Okay, so for MLC 30 years or above, and for MLA 25 years or above. Next one is he must possess other qualifications prescribed by the parliament. So other qualifications prescribed by the parliament is also of quality, or you can say these qualification must possessed by that MLA and MLC. So for important, he is a citizen of India. He subscribe and take oath in front of the officer of the prescribed by the Election Commission of India. He must not be 30 years of age in case of MLC and 25 years in case of MLA, as well as possess other qualifications prescribed by the parliament. So I hope you understand the whole idea of the qualification of person who wanted to elected or contest the election for MLA and MLC. So in this picture, you can place various member of various MLA and MLC of a state legislature. That means legislative council and legislative assembly. Now let's move on to next topic. Objective behind secular nature of Indian state. Okay, so secular nature of Indian state. What are the, you can say, objective behind the secular nature of Indian state? So the Indian Constitution mandate that the Indian state be secular. So it is written in the Constitution. The Indian Constitution mandate that the Indian state be secular. According to the Constitution, only a secular state can realize its objective to ensure the following. Okay, in Constitution it is written that only a secular state can realize its objective to ensure the following. Okay, these are that one religious community does not dominate another. If there is a secular nature in the Indian political system or in the Indian state, in that state only one religion community does not dominate another religion. Some member do not dominate other member of the same religious group community. For example, one like Hindu and Muslim. So Hindu, if they are in majority, so they are not dominating the minority Muslim community. and some members do not dominate other member of the same religious community. For in Hinduism, there are many divisions. So one division do not dominate over the others. Next one is the state does not enforce any particular religion, not take away the religious freedom of the individual. State authority does not enforce any particular religion. That means does not enforce that all the you can say that state is a Hinduish, you can say Hinduism state or Islamic state. Like Pakistan, they declare we are Islamic state, but India it is not, because India is a secular country. So the state does not enforce any particular religion, not take away the religious freedom of an individual. You can't take away religion. Like I practice Hinduism, Buddhism, or Jainism. It is my choice, not the choice of a state. So these are very, very important points related to secularism of India. One religious community does not dominate other. Some member of do not dominate other member of the same religious community, and the state does not enforce any particular religion, not take away the religious freedom of individual. So in this picture, you can clearly see Christianity, Hinduism, Islamic, you can say Islamic religion, Sikhism, Jainism, as well as other different religions. So I hope you understand the idea of religious freedom. Now let's move on to the next topic called Uniform Civil Code, or UCC. Simply we call it as a UCC. UCC is one that would provide for one law for the entire country. UCC provide one law for the entire country and applicable to all religious community in their personal matters such as marriage, divorce, inheritance, and adoption. Okay. I think some problem occur. Yeah, I'm sorry. So UCC provide one law for the entire country and applicable to all religious communities in their personal matters such as marriage, divorce, inheritance, and adoption. Remember, personal matter of a human being is what? Their marriage, their divorce, their inheritance, and their adoption. There are other issues also, but in UCC, it caters these important issues. Article 44 of the Constitution lays down that the states shall endeavor to secure a UCC for the citizen throughout the territory of India. Okay, so it is written in our DPSP, Directive Principle of State Policy, in the Article 44 of the Constitution, that states shall endeavor to secure a UCC for the citizen throughout the territory of India. Okay, so the Article 44 is one of the directive principles. These, as defined in Article 37, in Article 37 defined are not justiciable, not enforceable in any court. So Article 44 is not justiciable, that is not enforceable by any court, but the principle laid down therein are fundamental in governance. What is principle laid down in Article 44 is fundamental in governance, but it is not justiciable. Remember, very, very important. Article 44 is not justiciable, but principle laid down in it is a very much, because fundamental in our governance. Fundamental rights are enforceable in court of law. We know that fundamental rights are enforceable, but DPSPs are not. While Article 44 uses the words like state shall endeavor to, you can say state shall endeavor to do their task, state shall endeavor to perform this activity. Other article in the Directive Principle chapter uses words such as in a particular strive, shall in particular direct its policy, shall be obligation of the states. Okay, so remember the word, catchy words. In Article 44, it talk about states shall endeavor, but in other article DPSP it talk about in particular strive, particular direct its policy, obligation of the state. That is, it look like these words are more command, or you can say more you can say influencing in nature than this word. State shall endeavor, that's it. Here it talk about in a particular strive, particular direct its policy, obligation of the state. So Article 43 mentions states shall endeavor by suitable legislation. So in Article 33, it is mentioned that it says endeavor, which is also written in the 44. But in Article 40, the difference is that Article 44 mentions states shall endeavor by suitable legislation, while the phrase by suitable legislation is absent in Article 44. In Article 44, it is written that states shall endeavor by suitable legislation, but in Article 44, that word is missing. All this implies that the duty of a state is greater in other directive principle than in Article 44. So what it implies? All the keywords are implied that duty of a state is greater in other DPSP than Article 44. Okay, because of the words, it talk about just states are endeavor, but in Article 43 it is written that states shall endeavor by suitable legislature. In other article, it is written that strive, direct its policy, obligation of the state. Okay, so all these things state that Article 44 is not much appealing to the state government. Otherwise, or on the other hand, other DPSPs are appealing. See, all Hindus of a country are not governed by one law, nor all Muslims, nor all Christians. We know that all Hindus of a country are not governed by one law, nor all Muslim, nor all Christian. Not only British legal tradition, even those of the Portuguese and French remain operative in some part. Not only Hinduism, Muslims and Christian, but also some British tradition as well as Portuguese and French are operative in some part of our country. So we know that in our country, different law for Hinduism, different law for Buddhism, different laws for Sikhism, different law for Muslim, different law for Christians, as well as you can say different legal tradition of British, Portuguese, and French are also present in some part of our country. In the Northeast, there are more than 200 tribes. In Northeast region, there are more than 200 tribes with their own varied customary laws. The constitution itself protects local custom in Nagaland. It is written in the constitution that protect the local custom of Nagaland, and similar protection are enjoyed by Meghalaya and Mizoram. So all these points indicate that it is a very much need that we have to brought UCC so that it can unify, or there is a one law for all the people of our country. Not We know that different law for Hinduism, different law for Muslim, different law for Christian. Different legal tradition of British, Portuguese, and French are also present, and as well as uh, more than 200 tribes are practice their own customary laws in Nagaland, in Meghalaya, as well as Mizoram. So we have to unify all these things and put on one law for the whole country, as well as cater their, you can say, unique customary law in that law itself. Okay. So in this picture, you can clearly see Uniform Civil Code for Christian, for Muslims, for other tribals who have practiced their customary law, for other legal tradition of British, Portuguese, and French. So we have to, it is mentioned in Article 44 that states shall endeavor to bring UCC for the whole country so that the whole country enjoy the fruit of UCC. So I hope you understand all these 5 topics. Okay. UCC, qualification of state legislature, qualification of members of state legislature, then preamble, next one is what are the other two? Secular and writs. Okay. Secular nature of Indian state as well as different types of writs. Secular nature of Indian state and writs. So remember important points related to all these 5 topics. 5 types of writs. Under Article 32, Supreme Court issue. Under Article 236, High Court issue. India is a secular in nature. Okay. And there are under Article, I think 3, 4, under Article, I think, not article, but Indian Constitution mention the secular nature of India. Okay. Preamble, we know that important keyword, right? Sovereign, socialist, secular, democratic, republic, liberty, fraternity, equality. Qualification, we know that age of 25 for MLA, 30 for MLC and UCC. One law for all the citizens of India. For Hinduism, for Christians, for Muslims, for you can say other legal system which are practice of British, French, Portuguese, as well as different customary tradition of Nagaland, Mizoram, and Meghalaya. So I hope you understand and enjoy the whole idea of polity and different aspect of it. Now we are going to solve 5 questions based on these 5 issues. Okay. Just a minute. I think of the question. But yeah, I'm sorry. Yeah. So now we are going to solve 5 questions on the 5 different issues. First question is, which of the following does not find mention in the preamble of India's constitution? We talk about preamble of India. So the words are social justice, yes. Justice of social, economic, and political. It is written down in the constitution. So this one is correct. Equality of status, yes. Equality of status and of opportunity. This one is also there. Liberty of worship, yes. Liberty of thought, expression, belief, faith, and worship. Liberty of religion, no. This is not mentioned. So 1, 2, 3 is mentioned and 4th is not. So select the correct answer. Correct answer is I think 1, 2, 3, na? Liberty of Achha, I'm sorry. It is said does not find mention. Okay. So all these 3 are find mention. 4th one is not. So option D is correct. Just check we are on the right path or not. Option D is correct. That means we are on the right path. Now let's move on to the second question. Consider the following statement regarding in India, the Supreme Court and High Court can issue prerogative writs under Article 32. No. Supreme Court under Article 32, but High Court under Article 236. So this one is wrong. Both of them are issuing writ, but on different articles, not only on 32. The writ of mandamus cannot issue only the legal duty of public nature and whose performance of the applicant of the writ has a legal right. Yes, this one is correct. The writ of the mandamus cannot be issued unless legal duty of public nature and whose performance of the applicant of the writ have a legal right. So this one is correct. Third one is mandamus cannot be granted against the president or governor of the state. So this one is also correct. Mandamus cannot granted. So how many of the above statement are correct? 2 is correct, 3 is correct. That means 2 pair is correct. Correct. 1 is wrong. Just check we're on the right path or not. Yes. So option B is correct. That means only 2 pairs. And these 2 pairs are second and third. Now let's move on to the third question. Consider the constitution lays down which of the following qualifications for a person to be chosen as a member of the state legislature. First one is he must be a citizen of India. Yes. He must not less than 25 years of age in the case of legislative council. No. In case of legislative council, 30 years, and in case of legislative assembly, 25 years. So this one is wrong. Third one is he must make a subscribe to oath or affirmation before the person authorized by the election commission. Yes. 1 is correct, 3 is correct. That means only 2 pair. Option B is correct. Just check we're on the right path or not. Option B is correct. That means we are on the right path. Now let's move on to the next question. The Indian Constitution mandate that the Indian state be secular. The objective behind the mandate is okay. So Indian Constitution mandate that Indian state be secular. So objective behind it to ensure some member do not dominate other member of the same religious community. Yes, this is the purpose. This is the objective. To ensure one religious community does not dominate another. Yes, this one is also the objective. To ensure the state does not enforce any particular religion. Yes. To ensure the state does not take away the religious freedom of individuals. All the four options are correct. That means all 4 pair are correct. All the 4 are the objective of the secular nature of our Indian state. Okay. So option D is correct. Now let's move on to the next question. Consider the following statement regarding UCC, Uniform Civil Code. First one is UCC is one that would provide for one law for the entire country, applicable to all religious community in their personal matters such as marriage, divorce, inheritance, and adoption. This is the purpose. This is the definition of UCC. Article 44 of the Constitution lays down that it shall be the obligation of the state to secure a UCC for a citizen throughout the territory. It is not the obligation. States shall endeavor, but it is not the obligation. So this one is incorrect. Which of the statement is incorrect? So B. 2 is incorrect. Just check we are on the right path or not. B is correct. We are on the right path. So I hope you love this video, you enjoy this video, and gain some perspective, some knowledge about polity, political system, constitution, governance, and in the law and order situation, or you can say different legal remedy which is provided in our constitution. So I hope you love it, you enjoy it, and gain some perspective out of it. So namaskaram. Thank you.